3, go.
Assalamualaikum warahmatullahi wabarakatuh. I bid to Madam Putri. Today, me alongside my group mates, Anas, Hazim and Mikhail will be presenting Civil Court for our video exhibition. Without further ado, let's go to the introduction of our presentation today. Today's introduction will be about the Malaysian civil court system. Every country has its own unique established civil court system. This also includes Malaysia and our civil court system, which was founded by the British during the imperialization, and it was based on the Indian civil court system due to the fact that India was the crown jewel of the British Empire at the time. The civil court system has been responsible in resolving conflicts in a controlled manner, and it always resolved matters based on law, not justice. Our civil court system has also helped to establish Malaysia as a country with a systematic civil court system, which ensures the law to be followed by its citizens. Moving on will be the history of Malaysia's judicial system. This is a journey intertwined with past colonization and cultural growth. Next slide. The gateway of Malaysia's journey to establish a formal system of judiciary began after Captain Francis Light purchased the island of Penang. John Dickens, the first local magistrate, was appointed in 1801 and tasked with resolving disputes and enforcing the law. As the pressure on him grew, a royal charter was granted to Penang to establish a more sophisticated and well-funded Supreme Court of Penang, where cases were heard by a single judge known as the Recorder of the Supreme Court. This is to be said the starting point of Malaysia's experience in establishing a proper contemporary judicial system. However, Malaysia is a very unique country as it was colonized and divided by the British Empire. So due to this, we have a few different, each group of states has its own unique history of the starting point of its judicial system. Starting with the Federated Malay State, Perak, Pahang, Selangor, and Negeri Sembilan were united in 1896, resulting in the formation of the Federated Malay States, known as FMS. The court system had to be reformed as a result of the constitutional restructuring of these Malay Sultanate nations under the FMS. Initially, this resulted in the establishment of a common court of appeal known as the Court of Commissioner, which heard cases from the courts established in the FMS states. Moving on to the unfederated Malay states, Kedah, Perlis, Terengganu, and Kelantan, which prior to 1909 were actually under Siamese control. So they actually already had their own functioning judiciaries in place. After the British took control, however, all this was slowly replaced with English-trained judges and English-influenced laws. As with Johor, it's not 100% confirmed, however, it can be assumed that the judicial work was already being performed by the Supreme Court of Johor at the time of the appointment of a British advisor in 1914. Lastly, we have Sarawak. In order to maintain law and order at Sarawak, the first Raja, Brooke, had also taken on judicial duties, hearing cases in his own home. A number of courts were established to dispense justice in the name of the Raja of Sarawak under the second Raja Brooke, Sir Charles Brooke. This included native courts, Chinese courts, and the Kingdom of Sarawak Supreme Court, which was the highest court in the land. However, until around 1928, when Sarawak had its first legally trained judicial commissioner, Mr. Justice Sterling Boyd, who had also ensured the establishment of a proper judicial system based on legal principles, the judges of Sarawak courts were only administrative officers and were not legally trained. Next, I will pass on the floor to my groupmate Mikhail to talk about his part of the presentation.
So thank you, Munirah, for introducing all of us to what is civil court and telling us the brief history of civil court. So for the next part, it will be the organization of the structure of civil court. In this subtopic, I will be covering two parts, which is the hierarchy of court and monetary jurisdiction. So next slide, please. Okay, so first for the hierarchy of the court. The court system of Malaysia is built on a hierarchical system as to which The highest court of the land is the federal court, and then followed by court of appeal. And these are appellate courts in the country. And next would be the High Court in Malaya and High Court in Sabah and Sarawak, followed by various other types of High Court. This would be the appellate court and court of first instance. So for the last tier would be subordinate courts, which comprise the session courts and magistrate courts and courts for children. These are the courts of first instance. And other than that, there would be the special court, where it deals specifically with matters pertaining to the rulers of the country, or in Malaysia, the Yang di-Pertuan Agong. Next slide. Okay, so next would be monetary jurisdiction. What is monetary jurisdiction? So the limit of judicial authority of a court, or the extent to which a court of law can exercise its authority over claim, cases, appeals, and other matters. That is monetary jurisdiction. The rationale for creating this idea of jurisdiction in law is that the court should only be competent to adjudicate in subjects with which it has some connection, or which fall within the geographical, political, or financial constraint of its authority. However, by discussing the monetary jurisdiction in Malaysia, we will mainly touch on financial constraint of judicial authority. So as mentioned above, criminal and civil trials are the two forms of trial dealt by court. The magistrate court is first, followed by the session court, the high court, the court of appeal, and lastly, the federal court. So, okay, so starting with the magistrate court. The magistrate court only accepts civil claim less than 100,000 ringgit. As with the session court, it is similar to England previous quarter session, but with a limit of 1 million ringgit and below. On the other hand, they also have unrestricted jurisdiction in cases involving motor vehicle accident, landlord-tenant dispute, and distress. For civil claims exceeding 1 million ringgit, the jurisdiction is changed to the High Court, where other than lawsuit involving motor vehicle accident, landlord-tenant conflicts, and distress, the High Court have unlimited civil jurisdiction and normally entertain cases when the demand exceeds 1 million ringgit. So the next court is the Court of Appeal. The Court of Appeal considers all civil appeals against decision of High Court. If the claim is for less than 250,000 ringgit, the judgment or order is simply for cause. The appeal is against the decision of judge in chambers on an interpleader summons based on undisputed facts. The Court of Appeal must first grant leave before accepting the case for appeal. It is the court of last resort for cases that commence in any of lower courts. So, and lastly, we have the federal court, which is Malaysia's highest court. When the federal court provides leave to do so, it can consider appeal of civil decision of Court of Appeal. And that is all on organization of the civil court. I will pass the mic to my friend Hazim to explain for the next part. The stage is yours, Hazim.
Thank you, Mikhail and Munirah, for the amazing introduction to the history of the civil courts and also the hierarchy and structure of them. So now I shall talk about the functions and operation of these courts, which are related to the law. Now, for me personally, I'll be talking about two main points, which are the functions of these courts and also the process of filing cases and starting legal proceedings. So let's jump right in. What does a court do? So now the sole purpose of a court is to allow for disputes to be settled in a controlled manner without the use of force or harm, which basically means you want to settle arguments or disputes or trivial matters without people getting harmed, without any violence. Now, because disputes can vary from different lengths and different reasons, each court sometimes has a specific role and function that they do. So now, sometimes we cannot comprehend what the case might be. So certain cases are broken down into different specializations and different divisions. So now this segregation is done to help ensure a smoother handling of cases by the courts and a smoother justice process. So now, what is this segregation? So basically, the segregation starts from bottom, the magistrate and sessions court, as explained by Mikhail. So now these courts, since they are the bottom court, they are the subordinate courts. They are very simple courts. So these courts are very simple in regards to their jurisdiction and roles, and they carry out and merely handle basic civil suits. Nothing too complex, nothing too complicated, and the monetary jurisdiction, as mentioned by Mikhail, is quite low. So now moving on to the next highest court, which is the high courts. So now the high courts are when things start to get more interesting and much more complicated. And since they have unlimited monetary jurisdiction, the high courts have a multitude of roles and specializations, which we will discuss in brief here. So first of all, the High Court Civil Division. So as its name states, it handles matters pertaining to the land, contract, inheritance, trust, administration actions, and family. Anything to do with civil matters, it mostly is referred to the High Court Civil Division. Next, we have the Family Court. Now, this court has a judge assigned to deal with family-related matters as to make sure that the privacy of a family is protected, and the judge is very, very well versed in dealing with family matters and how to handle families in court. And that is a reason why he is picked for that specific position, to make sure that all family-related cases are easier and smoother to be dealt with. Next, we have the Appellate and Special Powers Division. Now, as its name states, it deals with appeals to the court. So this division, it handles sometimes judicial reviews, administrative actions, and various civil applications under the Legal Profession Act 1976. And finally, since we live in a third world country, we are driven by our industry, we have the Industrial Court. So the Industrial Court, consistent within the Industrial Relations Act 1967, it aims to resolve industrial suits, as the court's name suggests. And it also supports social justice and maintains industrial harmony through expeditious court awards and collective agreements. Basically, that court is specifically there to handle cases pertaining to the industry and whatever happens in a factory. So now moving on, we have the appellate courts. So now above the high courts, we have the appellate courts, the courts of appeal, which means you cannot bring a new case to these courts. You have to bring an appeal to courts. So now the first court is the Court of Appeal. So the Court of Appeal is an appellate court of the judiciary system in Malaysia, and has jurisdiction to hear appeals against any high court decision relating to criminal and civil matters. So now basically this court has powers to hear any appeals from the local courts except the magistrate, but even then there are some exceptions to this case. But above that court, however, there is the highest court in the land, the Federal Court of Malaya. Now, the Federal Court of Malaysia is the highest judicial authority and has the final court of appeal in Malaysia. Its decision binds all courts below it, including the Court of Appeal, and all civil and criminal appeals from the Court of Appeal. In civil appeals, a litigant may appeal on a point of law, the rejection or admission of evidence in lower courts, and only by that can the appeal go to the Federal Court. No other circumstances will a case go to the Federal Court except as mentioned. And now, so once we know these division and segregation of courts, you might be asking, so how do we start a legal proceeding? But before we begin any legal proceeding, one has to consider the few following factors. First, the cause of action. Do we have a proper basis for making a claim to court, or are we just going to waste the court's time? Next, the limitation period. Are you within the time to file your claim? So now, in between a claim you want to make, or when the claim happened, and when you're filing for documents to the court, there's a certain time frame you can meet. If you go past that time frame, basically your claim becomes void. The court won't handle your case. And then you have evidence. How will you back up your claim? Do you have necessary evidence in the form of documents or witnesses? Basically, you can't go to a court, file a claim, and then have no evidence to back up your claim. The court will immediately throw you out. And finally, the cost of litigation. You will need to incur court filing fees, and litigation may take up to a substantial amount of your time. You should also consider the sad possibility of losing your case and the consequences of that, such as being ordered to pay your opponent's costs. Basically, in a civil case, if you lose, you are ordered to pay the cost of your opponent's litigation. So you have to take these factors into consideration. But once you do, we can move on to the next step, which is the mode of commencement. How do we begin these proceedings? So the first way you can do it is by doing a writ of summons. Now, a writ of summons in common law is a writ of formal written order issued by a body with administrative or judicial jurisdiction. In modern usage, though, this body is generally the court. So basically, a writ of summons is basically like warrants, prerogative writs, subpoenas, etc. They're basically documents that say to the court, here is my case, here is what I'm claiming for, and here are the people involved. So can we subpoena them and call them in together for a warrant so they can appear in court? So that is a writ of summons. Another way we can commence court proceeding is by originating summons. Now, OS for short is the use when it is required by a statute, a dispute which is concerned with matters of law. Basically, originating summons comes into play when and only when there is no dispute of the facts of the case. The facts are all right, nobody is cheating or lying, or there might be misappropriation of the facts. This is all comes down to what the law pertains, and only then will originating summons come into play. So now, as I said before, once you know the commencement, you will have to take into consideration what happens when you lose a case. So for that, I call my good friend Anas to explain to us what to do and how to appeal when you lose a case.
Okay, thank you very much. Thank you very much, Hazim, for the thorough explanation on the functions of the case and how to file the case and all the other necessary things regarding to it. So to answer Hazim's question, so once you lose a case, you are able to process an appeal. So this is basically a means of making a request that the higher court reviews the decision and hopefully decide that you're right. But if you want this to happen, or there are actually a few requirements when you want to file an appeal. So firstly, you have to file a notice of appeal within 14 days from the date of the decision. In this notice, also have to include that whether you are appealing the whole decision or only a part of it. And appeals are broken down into 3 types, which are appeal as of right, appeal with leave of court, and also no appeal. Okay, next slide, please. All right, so firstly, we will have the appeal with leave of court. So this is where you have to ask permission, or you have to ask permission from the court to file an appeal. And this is all required only if your case is below 250,000 ringgit. And if the court does approve your request, then you can bring your appeal there. And if it doesn't, then you cannot. And secondly is appeal as of right. So this is where you do not have to ask permission from the court to do an appeal, because you are already subjected to it by the law or by right. And this only occurs if your case is 250,000 ringgit and above only. And lastly, next slide, please. We will have the no appeal. So this is basically where you have no right at all to appeal to the Court of Appeal. And these are in circumstances where the judge already made a decision towards your case where it cannot be authorized anymore, or to basically say it's the final decision. All right, moving on to the next part, which is legal personnel and their job specification. So I will be talking about 3 legal personnel and also their job specifications. All right, next slide, please. So firstly will be the judges. So this person will be the most important person in the court, because he will interpret and apply laws and precedents to determine rulings on legal matters. And the judges will oversee the trials, hearing, and other legal proceedings, so they comply to the law. Judges are also either appointed or elected. Next, we will have the lawyers. They will be the ones who will be representing the defendant or the plaintiff, and they provide counsel and represent businesses, individuals, and government agencies in legal matters and dispute. And lastly, we will have the courtroom interpreter. So this person will make communication possible in the courtroom due to their high skill regarding to languages, but they also have to have high understanding on legal issues. And these interpreters will help all people involved to understand the proceedings regardless of the language they speak. Okay, so we have come in to our presentation on civil courts. Thank you for your your time and attentive listening. And thank you also to Madam for giving us the opportunity to represent our topic. And I hope everybody has a good day. Thank you very much.